This session is being recorded for official purposes. Good evening, your lordships and learned councils. Welcome to the 6th TGA Virtual Moot Court Competition. My name is Chavidas and I will be acting as the court master for this session. It is my distinct honor to welcome our esteemed judges for this round. First is Advocate Dr. Surapalli Prashant. He is dual qualified in medicine and law, having graduated as a medical doctor turned lawyer from the reputed Sun Yat-sen University in Guangzhou, People's Republic of China, with an MBBS degree in 2011. Later, his interest and passion towards law made him join 3-year LLB course in the year 2013, and he obtained his LLB degree in First Division in the year 2016 from the MSS Law College, Chadarghat, affiliated to Osmania University. He secured state 10th rank in the TS/PG LSAT LLM entrance exam, and he pursued a 2-year LLM degree with a specialization in international trade and economic law from the University College of Law, Osmania University, and secured first division in the LLM course in the year 2021. He has also pursued a PG diploma in international humanitarian law from Nalsa University of Law and obtained an overall A grade in the said course in the year 2021. He is also currently pursuing his PhD in law as a part-timer PhD research scholar from the ECFI Law School, Hyderabad, which is a constituent of the ECFI Foundation for Higher Education, IFHE. He enrolled as an advocate on the rolls of Bar Council of Telangana, then Composite Bar Council of Andhra Pradesh on 1/9/2016, and joined the chambers of his mother's Honorable Mrs. Justice Surapalli Nanda as advocate, as she then was, and then practiced in Telangana and Andhra Pradesh High Courts and gained experience in handling various types of constitutional, civil, criminal, labor, revenue service, and arbitration matters, and continued in the said office till her elevation as Judge, High Court of Telangana, that is till 24th March 2022. He has also assisted his father, Sri Surapalli Madhav Rao, who is a retired principal district and sessions judge and currently a practicing advocate in the AP High Court and as a junior counsel. Since March 24, 2022, he has been practicing independently as an advocate. He specializes in constitutional law, criminal law, international law, and service law. He has dealt with writ petitions, writ appeals, criminal petitions, seeking quashment of FIR, bail applications, and civil revision petitions. He has been invited as a moot court judge in various intra-moot courts and national moot court competitions as well. He is also a prolific author in the field of law, and about 26 articles and research papers have been authored by him and published in various regional, national, and international journals. He has authored 2 books in the field of law, published by LAP, Lambert Academic Publishing, Germany, translated into 6 languages. He has also qualified the TS SET exam 2023 in his first attempt and is currently appointed as a Special Assistant Public Prosecutor in the High Court for the state of Telangana and continues in that capacity. Thank you, sir. We have our second judge, Advocate Sagar Suri, sir. He has completed his BSL LLB from ILS Law College, Pune, and his Masters in Business Laws from NLSIU, Bangalore. He is an advocate on record at the Supreme Court of India, and he is currently the counsel for the Municipal Corporation at Delhi before the High Court of Delhi. He has also previously served as a standing counsel for the Income Tax Department, Ministry of Finance, Government of India before the High Court of Delhi. We thank both of you for your valuable time and efforts in adjudicating this session. Before we proceed, kindly ensure you have a stable internet connection. Please keep your cameras turned on throughout the proceedings. Any technical glitches must be communicated immediately through the chat box. And in the case of disconnection, a maximum extension of 5 minutes will be granted to the affected counsel to reconnect. The session will be recorded for official purposes, as I mentioned in the start. With your permission, sir, may I proceed to outline the rules of the competition?
Yes, proceed.
Thank you. Counsel 1 and Counsel 2 for the appellant will present first. This will be followed by Counsel 1 and Counsel 2 for the respondent. Each counsel is allocated 15 minutes, and any extension is solely at the discretion of the bench. However, I humbly request the bench not to permit any extension due to the fixed schedule. I will be strictly monitoring the time. Screen sharing of documents or judgments is permitted only with the prior permission from the bench. So, with your permission, we may begin with the counsel for the appellant.
Yes, please begin.
Thank you. All the best to all the teams.
My time starts with 3, 2, 1. May it please your lordships, the council seeks permission to approach the dais.
Yes, please.
Much obliged, your lordships. Good evening, your lordships. The council recognize the gracious presence of this honorable bench. For the convenience of the proceedings, may the council refer the bench collectively as a lordship.
Yes.
Much obliged, your lordships. Council is appearing before this honorable court in the matter of ABC Bank versus XYZ Private Limited on behalf of the appellant, challenging the order passed by the NCLAT. Your lordships, the present matter raises four critical issues for determination. The first and the fourth issue will be dealt by me, and the other remaining issues will be dealt by my co-counsel. The council shall address these two issues for the next 14 minutes, reserving 1 minute for rebuttal. Your Lordship, the council seeks permission to briefly state the facts of the case.
Yes.
Your Lordship, the
Make
respondent
it brief,
corporate.
very brief. Yes.
Yes, Lordship. The respondent corporate debtor was declared as an NPA, non-performing asset, in 2014 when it defaulted in the making of the payments of loan it had took from the appellant financial creditor. Subsequent to that, the corporate debtor issued various one-time settlement letters to the financial creditor from 2014 onwards. In 2020, an one-time letter one-time settlement letter was sanctioned by the financial creditor in which the corporate debtor made another default in payment. Therefore, the financial creditor files an application for the initiation of the CIRP process, stating that the date of default is to be taken as 1st of May 2020. The application came to be dismissed by the NCLT, being barred by Section 10A, which was inserted to protect the company with genuinely occurred losses due to the COVID-19 pandemic. Then again, the matter goes before the NCLAT and it is dismissed there too. Thereafter, the financial creditor files another application stating that the date of default is to be taken as 1st of April 2014. The NCLT dismissed the matter on the grounds that the financial creditor cannot change the date of default on its whims and fancies, and the application is barred by the res judicata. Thereafter, the matter goes to the NCLAT again, and the NCLAT too dismisses the appeal on the same grounds. Ultimately, the matter is before this honorable court. If your lordship are well versed with the facts of the case, the council seeks permission to proceed directly to the arguments.
Yes, proceed.
Coming on to the first issue, whether or not a second application under Section 7 of the Insolvency and the Bankruptcy Code is barred by law. Firstly, your lordship, I would like to submit that uh, res judicata does not apply where the prior application was not decided on merits. That the insolvency and the bankruptcy code does not explicitly prohibit the financial creditor from filing a second application. The doctrine of res judicata comes into play when the earlier application has been finally adjudicated on merits. In our case, the first application was dismissed only because of the temporary suspension under the Section 10A of the Insolvency and Bankruptcy Code.
According to you, what is the limitation period for an application under Section 7 of the IBC code?
Generally, it is 3 years
3 years.
from the date of default.
Which section in the Limitation Act speaks of that? Which section or which article?
Uh, I'm sorry, Your Lordships, I'm not well aware of that
Okay,
limitation. Shall I proceed with my
proceed,
submission?
proceed.
Uh, Before the NCLAT, in the case of SBI versus Athena Energy Ventures, uh, the NCLAT has categorically held that where a previous application is not decided on merits, a fresh application under Section 7 is maintainable uh, as long as the debt subsists and the cause of action continues. That is precisely the situation in our case, where a second application came to be filed during the subsistence of an ongoing cause of action. Similarly, in the case of Dena Bank versus C. Shivakumar Reddy, the court held that part payments and subsequent acknowledgements may furnish a renewed date of default, and that a second application based on such a renewed cause of action is not barred by res judicata. Thus, the position of law is settled in this matter, where the debt continues and the debtor acknowledges it. The financial creditor has the right to apply under Section 7. Secondly, Your Lordship, acknowledgements made under the Section 18 of the Limitations Act creates a fresh period of limitation. Your Lordships, in this court, in the case of Asset Reconstruction Company versus Vishal Jaiswal, has conclusively settled the legal position that an acknowledgement of debt under Section 18 extends the limitation of IBC proceedings. Further, in the case of Lakshmi Pat Surana versus Union Bank of India, this honorable court reaffirmed that a valid acknowledgement before expiry of limitation triggers a fresh limitation period, enabling a new Section 7 application. In our case, Your Lordship, there are various written acknowledgements in the form of the various one-time settlement letter issued from 2014 onwards, which are well within, and the last one-time settlement letter being issued on 1st of January 2020. The second application is well within the limitation. Thirdly, Your Lordships, the object of the Section 7 of the Insolvency and Bankruptcy Code is to empower the financial creditor in case there is a default. Uh, the NCLT has the jurisdiction to examine all issues related insolvent or unable to pay the debt. Therefore, once default is established, you're not able to hear your lordships here. Like
Can you hear me now?
just
Am I audible?
yes, lordship.
Am I audible?
Yes.
Okay. So I wanted to ask you one thing, that you're saying that the subsequent Section 7 application is maintainable. So firstly, is it your case that you are abandoning your first?
Not before the NCLAT and even the NCLAT dismissed the first application on the same grounds. So I uh, uh, even opportunity was not given to us under the Section 7 subsection 5, in which it is stated that the adjudicating authority may give a chance opportunity to rectify the defect which is in the first application. So therefore, if such opportunity was given to us, we would ultimately have used that opportunity and would have made the necessary amendment for our application to be admitted before the NCLT.
Right. All right.
Your Lordships, if you are satisfied with my first submission, the council seeks permission to move on with the next issue.
Yes.
Much obliged, Your Lordships. Coming on to the fourth issue, whether or not a case can be admitted if the default has occurred and the application is well within the limitation despite an error in the date of default. Firstly, Your Lordship, the object of the insolvency and bank, I would like to point out what is the object and of the insolvency and bankruptcy court. But Your Lordship, it is humbly submitted that when there is occurrence of default is undisputed and the application is filed within the limitation. A mere error or defect in stating the date of default cannot defeat the maintainable admission of a Section 7 application. The Insolvency and Bankruptcy Code prioritizes substance over form, and clerical inconsistencies cannot override the court's objective of resolving genuine financial distress. Secondly, Your Lordships, IBC expressly permits the correction of defects. Under this Section 7, subsection 5, uh, the, I- uh, the IBC itself provides for an opportunity to the creditor to rectify any defect or error in the application made for the initiation of CIRP process within a period of 7 years. So the error of in the date of default could be cured and the application can be admitted. In the present case, no such opportunity was given to the financial creditor to cure the error in the date of default as the application was found to be barred by Section 10A. The financial creditor makes another application with a delay of 2 years from getting the first application rejected from the NCLT. It is humbly submitted that this delay is condonable by the NCLT. This court, in the case of Surendra Trading Co. versus Jugilal Kamlapur Jute Mills, has already held that 7 day period is directory, not mandatory. The NCLT is empowered to condone delay in curing defects when there are justifiable reasons preventing rectification within the 7 days. Uh, Therefore, Lordships, it is humbly submitted that a case can be admitted if the default has occurred and the application is well within the limitation period, despite there being an error in the date of default. My lordship, the council seeks permission to retire and allow my co-counsel to make submission on the remaining issues.
Yes.
Much obliged, your lordship.
May it please the court, I am the counsel appearing on the behalf of appellant. With your lordship's kind permission, I'll be proceeding with arguments advanced on issue number 2 and 3.
Yes. Proceed.
So your lordship, the second issue of argument advanced asks about whether or not mentioning date of default is mandatory in application under IBC. So your lordship, my core contention is that omitting or erring on the exact date of default does not defeat Section 7's application provided the existence of default is substantially proven. It does not defeat Section 7's application. Your Lordship, IBC is a piece of beneficial legislation. It places substance over form. Thus, the proof of default supersedes technical precision. The omission or the technical error in specifying the exact date of default is not fatal for the Section 7's application, provided the existence of default is proved. Section 7, Clause 3, Clause A of the Code merely requires financial creditor to record the default and provide evidence thereof. It does not mandate that the specific date is to be mentioned. So I place a strong reliance on the landmark case of Innovative Industries versus ICICI Bank, where the Honorable Court held that an adjudicating authority's primary duty is to ascertain if the debt is due and if the default has occurred. So, in the very present case, the debt of rupees 500 crore is undisputed. The non-payment is undisputed. Thus, the respondent has acknowledged this debt repeatedly by OTS from 2014 to 2022. So, Your Lordship, the NCLT dismissed our application on the grounds of hyper-technicality. However, as established in the case of Dena Bank versus Shivakumar Reddy, the court should not be interpreted in a way that defeats its objective of resolution. Also, whether the date is treated as NPA date or the OTS failure date, the fact remains that the public money is lost. Thus, therefore, to dismiss the petition solely on the mentioning of the date of default is to prioritize procedural formatting over substantive justice. If it may please the court, I'll proceed with the issue number 3.
I have a question.
Yeah,
Can
yes,
the
your lordship.
financial creditor amend date of default even if pleadings are closed?
Uh, you're not audible, your lordship. Can you repeat the question?
Can you're a financial creditor, right? Can he amend date of default even if the pleadings are closed? Do you have
No.
any judgments to that effect?
Uh, yes, your lordship. Mm, in the case of yes, your lordship. In the case of okay. So your lordship. In the case of RBI versus SRER infra, it was held that missing or incorrect default date does not defeat the does not defeat the maintainability if the document shows the default. So as per this case, even if the date of default is changing, it does not defeat the maintainability.
Okay.
Yes, my lordship.
But then, counsel, I just have a follow-up question in follow-up to the question which my brother asked you. The question is that if
Yes, my lord.
date of default, firstly, according to you, what does date of default carries any significance or not? That's my question number one. And second
Mhm.
thing is that if date of default is so flexible that you change it from one date to another without seeking the leave of the court, and if date is of such insignificance in its character, then why do you think the date of default is specifically asked for in a section 7? So naturally, it has to carry some weightage. According to you, what is the significance of date of default?
Your lordship, date of default is the it's your lordship, the date of default is mandatory. You have to default, but the exact date of default is not mandatory. I in the case Supreme Court said that uh, there must be existence of default, not a procedural perfection or a specific data or a specific debt. In the case of SRER, the petition NCLT rejected just because the date of default wasn't mentioned, but the exact date of default the exact date of default the is not a mandatory provision. It can be changed based on circumstances and facts.
But don't you think that date of default is important because that is the date from which time the limitation period begins to run?
Date
Don't
of
you think so?
In
Because
our case, the lordship.
otherwise you being the appellant or you being the
Hmm,
applicant, how
hmm,
will you compute the period of limitation as whether you are within limitation or outside limitation?
hmm.
So don't you think date of default is important for the purpose of computing the limitation and to tell the court that the limitation, according to the applicant, rightly or wrongly, it started from this X particular date. Don't you think so?
Yes, my lordship, but yes, yes, but in our case, the case is of continuing default. In our case, the respondent was continuing it with OTS letters. Thus, our case is of continuing default. The respondent the limitation period of 3 years extends because of it.
Thank you. Thank you. That's what I was looking for. Thank you.
Okay. If you may, if you may please, I'll be proceeding with issue number 3. So, the third issue of an argument advance asks whether the date of default changes based on the facts or is it tied to the date of NPA. So, Your Lordship, the date of default is dynamic and is fact dependent. It is not rigidly tied to the date of NPA. The lower court erred in equating the NPA date solely with date of default. The NPA is regulatory classification by the RBI, while the default under Section 3 Clause 12 is simply non-payment of dues. While the NPA date is the starting point, the date of default evolves when the corporate debtor acknowledges the debt or the promise to pay. Your Lordship, the corporate debtor issued a separate letter requesting restructuring of OTS between 2014 and 2022. So, according to the case of Lakshmipad Surana versus Union of India, every time the corporate debtor acknowledges the debt in the balance sheet or via OTS, a fresh limitation period begins, and arguably a fresh cause of action does arose. So also in the case of Dena Bank versus Shivakumar Reddy, it was observed that a subsequent acknowledgement can furnish a fresh date of default. Also, we sanctioned an OTS letter on 1st February 2020, and the respondent failed to pay by 31st March 2020, and we cancelled it on 1st of August 2020. So the moment we failed to pay the OTS amount, a new default has occurred. Therefore, when we filed the second application citing the 2014 date of default, uh, sorry, citing 2014 NPA date supported by continuous acknowledgement, we were legally correct. We entitled to rely on the original NPA date read with the subsequent acknowledgement that kept the debt alive. Thus, to hold that the date of default is frozen at the NPA date 2014 ignores the commercial reality of the banking, whereas the settlements are attempted, the respondent cannot be benefited from their multiple requests of OTS to delay the process and then claim that that it is technically barred because the date has changed. That's it, Your Lordship. If you may be pleased, I'll proceed with the prayer.
Yes, proceed.
If your lordships are satisfied with the argument advanced, the council humbly prays for the following relief. First, set aside the impinged order passed by NCLAT. Secondly, issue direction to the NCLAT to take up the matter. Thirdly, as any other order that this honorable court may deem fit. It was precisely good to argue in this of this court.
Yes, thank you.
Respondent side, you can start. TGA 41, speaker 1.
The council is having a technical glitch. Give us a couple of minutes till she fixes.
Okay.
The council seeks permission to approach the dais.
Yes, proceed.
Much obliged, Your Lordship. The council is appearing in the case of ABC Bank versus XYZ Private Limited on behalf of the respondents. The council seeks permission to collectively address the bench as Your Lordships.
Yes.
Much obliged, Your Lordships. The council shall address issues 1 and 2 in 14 minutes, reserving 1 minute for sub-departments. The co-council will be dealing with issues 3 and 4. The researcher is also present, Your Lordships.
Yes.
The first issue being your lordship. If your lordships are well versed with the facts, the council seeks permission to move on to the legs of the arguments, your lordships.
More
Much,
Yes.
much obliged, your lordships. The first issue being whether a second application is allowed or under Section 7, your lordship. First of all, the respondent most respectfully submit that the second application that has been filed by the financial creditor under Section 7 of the IBC is barred by law and it is not allowed to be filed, your lordship, on the grounds that this constitutes an abuse of power. It also goes against the legislative intent of Section 10A that was introduced through the way of amendment, and it also burdens the judicial process, your lordship. The council shall be dealing with issue number 1 and 2 legs. Firstly, that Section 10A creates a complete and permanent bar, and that the principle of res judicata is applicable, and there is a limitation on IBC's ban on repeated filings, your lordship. Section 10A was introduced by way of amendment in the year of 2020 in order to help companies that were facing financial distress, your lordship. If your lordships may observe, the OTS, that is the one-time settlement, was provided in the date of 31st of March 2020, your lordships, which was the period of the ongoing COVID, your lordships. Further, the appellants have relied upon this date, the date of the OTS failure, that is the 1st of May 2020, your lordship. They have relied on this date in order to initiate the CIRP, your lordship. However, during this period, the company itself was undergoing financial distress and was also governed by Section 10A that was implemented in the start of the year of 2020, your lordship. Hence, this application before the NCLT and NCLAT, they stand corrected in dismissing the case based on merits of the bar of Section 10A, your lordships. Changing the default date in the second application is not a correction, but an attempt to get around the statutory bar, your lordship. All the appellants are trying to do is misguide the court by stating the OTS date as the date of default, your lordship. It can be noted in Jagdish Prasad Sarda versus Allahabad Bank, your lordship, that your lordships, the respondent seeks permission to share the screen in order to show the case, your
Yes.
lordship.
Yes.
Much obliged. In Jagdish Prasad Sarad versus Allahabad Bank, your lordship, the court held that NPA date should be mentioned as the date of default, your lordship. That is the non-performing asset. The date when the non-performing asset was declared, that itself should be the date of default, your lordship. In the present case, the NPA was declared on the 1st of April.
Which para do you want us to read?
Your lordship, just a minute. The researcher is trying to locate it.
No, you
Yes,
should
your
know
lordship.
the
Para number 10, your lordship.
para number. Please focus it on
10,
para
your
10,
lordship.
please. And can you reduce the bar so that it comes?
Just show the 10.
It was okay previous. Yeah, this is fine. This is fine. So can you just take us to para 10? From where the para 10 starts.
It's fully above. Yeah, that's all. Your lordship, only the
What is
highlight.
relevant? Yeah. You just tell me the relevant part. Tell me.
Your lordship, it is therefore manifestly clear that the date of default will be the date of declaration of account as NPA, and such date of default would not shift, your lordship.
Okay, all right.
That is the
so
relevant
the point which you are trying to buttress with this judgment is that their argument that date of default is different from the date of the account being dead as NPA. That's the wrong proposition which they are saying.
Indeed,
the correct proposition is that the date of default is the date when the account has been declared by the bank as an NPA account.
Indeed, your lordship.
But then tell me one thing. Are you aware about the process which a bank has to follow while declaring an account as an NPA account? Are you aware of that process?
Indeed, your lordship.
I'm not asking you the complete details of that whole process, but the point which I'm trying to get at is that normally our experience in the practical legal setup has been that, say for example, default happens on 5th of December 2025.
Indeed,
So
Your Lordship.
there are couple of processes which the bank has to follow, such as giving notice to the person who has committed the default, then wait for
Indeed.
his reply. Then there is a committee which is formed, which has to take a call on whether to declare and not to declare. So there is always a hiatus, or there is always a time gap between the date when the actual default had occurred and the date on which the bank declares the asset as an NPA. There is always a hiatus. It is not as if that on 5th I commit a default and on 6th the bank declares me as an NPA account.
Indeed, Your
So
Lordship.
how would you defend that proposition? That if they are saying that the date of default is when the actual default occurred and not when NPA was declared by the bank, so they are not entirely wrong when they say that. How would you defend that point? That no, why we should this judgment there? That's very good on your part that you have researched on this. But what do you think would be the rationale that the date of default should be the date when the NPA is declared and not when the actual date of default when the default had occurred? And one more point, that say for example once an account has been declared an NPA account, we did that, say for example on 5th the actual default occurred,
Yes,
and
Your
on
Lordship.
25th of December the bank declared the account as an NPA account.
Indeed, Your
So
Lordship.
there's one more proposition which I would want your argument on, that
Indeed.
why don't you think that the date of default should relate back to 5th of December? Why not? Because
Indeed, Your
once
Lordship.
the bank has declared the account as NPA account on 25th of December for a default which had occurred on 5th of December,
Indeed, Your Lordship.
then in all fairness, the date of default should relate back to the date when the, are you aware of the doctrine of relation back, right?
Indeed, Your Lordship.
That whenever a judgment is passed, it dates back to the date when the complaint was filed or when the case was filed.
Indeed, Your Lordship. Your Lordship, the council would like to answer your question. Firstly, relying that as to what are the procedures that the bank should follow while declaring an NPA. It is governed by the RBI guidelines, Your Lordship, and as Your Lordship rightly mentioned, it gives a timeline of 90 days for the debt to be covered and further declares it as a non-performing asset, Your Lordship. Further, moving on to your lordship's question as to why the NPA is to be considered as the date of default and not the actual date of default, your lordships. The council would like to clarify that in the in Milind
I have
Kashiram
one
Jadhav.
question. Are you aware of the fact that Section 18 of the Limitation Act is also applicable to applications filed under Section 7 of the IBC Code?
Indeed, your lordship. Section 8 or Section 18 of the Limitation Act talks about the acknowledgements being as a document, your lordships. Indeed.
Do you have any case law to support your contention?
Your lordship, I would like to seek clarification regarding what contention, your lordship. I mean,
regarding whether an adjudicating authority can examine the material placed on record by the corporate debtor to determine whether an application filed by financial creditor is not beyond the period of limitation.
Indeed, your lordship. The council seeks just 1 minute of time. Just say this. Your lordship, in the case of Ishrat Ali versus Cosmos Cooperative Bank Limited, it was expressly mentioned that the mentioning of date of default plays a vital role in calculating the debt and the limitation period, your lordship. Hence, this itself serves as a judgment that makes it important, your lordship.
So that is the adjudicating authority, that is the NCLT and then the NCLAT, duty bound to scrutinize the application filed under Section 7 of the code and come to a conclusion whether such application is barred by limitation, even in the absence of any plea with respect to limitation.
Indeed, your lordship, the procedure that has been established by various case laws mandate that there has to be a subsequent finding through which it has to be dismissed, your lordship. However, if you observe the language that has been used in the proposition itself, it says that it was barred by Section 10A. let me just clarify what Section 10A has been provided, Your Lordship. Section 10A states that, as per the said amendment, no application whatsoever can be filed for initiation of the corporate insolvency resolution process, Your Lordship. And in the instant case, the NCLT and the NCLAT has relied upon this language that has been used in the Section 10A amendment and has therefore used it to dismiss the case, Your Lordship. Further, relying back to the date of the default that has been mentioned, Your Lordship, under Code of Civil Procedure itself, there exists an alternative remedy for the appellants to have remedified the mistake of the date of default, Your Lordship. It was not mandatory for them to apply for a fresh application, that too with a gap of almost 2 years, Your Lordship, and then approach the bench with the same matter of issue, Your Lordship, which would amount to res judicata, Your Lordship.
Yes, proceed.
Indeed, much obliged, Your Lordship. Your Lordship, yes, I would just like to clarify more on the aspect of res judicata, Your Lordships. So, res judicata states that when there has been an involvement of the same parties in the same subject matter and a final judgment has already been given in a matter, it cannot be adjudicated again, Your Lordship. Here, in the instant case, the express language used is that under para 9, Your Lordship, the same was also dismissed on merits, Your Lordship. Here, dismissed on merits can be inferred to mean that the case was dismissed after the NCLAT did its own findings, submitted its own documents, and then it was dismissed on merits, Your Lordship. Hence, the NCLAT stands corrected in dismissing the appeal, which has been barred by Section 10A, Your Lordship. If Your Lordships are satisfied with issue 1, the council seeks permission to move on to the issue number 2, Your Lordships.
Yes.
Much obliged, Your Lordships. The issue number 2 being whether the mentioning of date of default is mandatory in application under Insolvency and Bankruptcy Code, Your Lordships. And we humbly submit that it is a mandatory requirement under the IBC itself, Your Lordship. The explicit mention that date of default is mandatory has been mentioned under Section 7, which has to be read with Rule 4 of the Insolvency and Bankruptcy Application to Adjudicating Authority Rules of 2016, Your Lordship, which prescribes a Form 1 that has to be submitted to the court for the adjudicating process, wherein if the Form 1 prescribes that the details of the corporate debtor be given, as in the name of the corporate debtor, the amount of the debt, and the date of default, Your Lordship. Here, when the date of default is being mentioned, such date of default has to be the date of the date when the corporate debtor was classified as a non-performing asset, Your Lordship. And as clarified earlier, that was held that the NPA date should be the date of default was held in Jagdish Prasad Sarda case, Your Lordships.
Tell me one thing. I have a question for you.
Indeed, Your Lordship.
It's a very principle based question.
Your Lordship, I'm extremely sorry, but you're not very loud, Your Lordship. It's very
hear
low.
me?
I can hear you,
me
Lordship,
now?
but the volume is very low.
Actually, I am shouting. So there is something which you have to do with your speaker.
I
Can
apologize.
everybody else hear me? Everybody else hear me?
Yes, yes.
Yes, Your Lord.
Right. So tell me one thing that
Indeed, Your-
tell me one thing that say for example in this case in particular, now there is a dispute with respect to the aspect of limitation, aspect of date of default. So
Indeed.
according to you, will the limitation aspect and the date of default aspect has to be decided first before going on to the merits of the application, or can the adjudicating authority or the NCLAT decide the main issue or the main merits of the issue or the main merits of default first, whether there was actually any default or not, and what kind of default was it, and whether the creditor is a financial creditor or not, and then proceed to examine on limitation? Or will the adjudicating authority have to decide on the aspect of limitation first and give a finding on that first, and then proceed to decide on the merits of the application? What do you think? Can the adjudicating authority decide on the merits of the application or the qualification of the financial creditor first before giving a finding on the limitation aspect? What do you think?
Your Lordship, the Council would like to firstly seek extension of 2 minutes as this.
Yes, yes, that's granted. That's granted. That extension
Much
is
obliged,
granted.
Your
Yes.
Lordship. Further, the Council thinks that it is important for the NCLAT to go along or to give rules that are persistently there, Your Lordships. As to answer your question of whether it should determine the limitation first or whether the credentials of the parties, Your Lordship, the court should it should determine the limitation of the acts, Your Lordship, and then move on to the merits of the case, wherein the merits of the case is indeed involved into the aspect of determining the limitation as well, Your Lordship. So when the court is deciding upon merits, it will look into all these aspects itself, Your Lordship.
Very good. Thank you.
Much obliged, Your Lordship. Your
Conclude
Lordship,
the-
indeed, much obliged, Your Lordship. Just to state one more case, Your Lordships, I would like to state Innovative Industries Limited versus ICICI Bank itself, Your Lordship, which established the legal principle that an incomplete application ought not to be admitted, Your Lordship, which can be inferred that even if an application was admitted without the date of default being correct, it cannot be adjudicated upon that, Your Lordship, as in it has to be dismissed again, Your Lordship. The Council would, if Your Lordships are satisfied with the submissions, the Council would seek permission to call my co-counsel to deal with the
Yes,
further
yes.
issues. Much obliged, Your Lordships.
Greetings, Council. Greetings to my fellow councils and to the honorable bench. The council would like to confirm if I'm audible and clearly visible.
Yes.
Your lordships, the council, the second council shall be dealing with issue 3 and issue 4. Your lordships, issue 3 deals with the question whether the date of default should be considered as the date of NPA or whether should it be determined on facts and circumstances. It is most humbly and respectfully submitted before this honorable court that the date of non-performing assets NPA should be considered as the date of default in all bank matters. Your lordships, the council would like to substantiate the argument by presenting the case of Milind Kashidham Jadhav versus State Bank of India and another. The council seeks permission to present the case before this honorable court.
Yes.
Your lordship, in the said case in paragraph 56, it was held that the RBI regulations are not arbitrary in nature. They serve as a threshold indicating a lapse in repayment obligations, stating that the NPA is an objective indicator to determine the date of default. So thus it serves as a pivotal measure for not only maintaining the financial health and stability of the banking sector, but also as an indicator as to when the first date of default occurred. Furthermore, the Honorable Court of National NCLT Bengaluru has also upheld in the case of Pratik Apparels Private Limited versus Canara Bank that the date of NPA is the valid date. Is the valid and the appropriate date for determining the date of default. Your lordships, the date of default does not change or shift based on any kind of acknowledgement of debt, be it by restructuring letters or through OTS letters. The date of default is static and does not shift. The all it does is it extends the limitation period. The mentioning the date of default in the application gives an objective picture to the bench as to when the first date of default occurred, and the acknowledgement of debt only extends the limitation.
Are you aware of this case, Babulal Vardaji Gurjar versus Veer Gurjar?
Period. Your lordships, this observation.
What did this case in the Honorable Supreme Court? What did it say?
Observation was case, your lordships. Your lordships, the Babulal case was essentially concerned that the Limitation Act is applicable to the IBC proceedings, Your Lordships. It basically recognized the Limitation Act, and that Section 5 may also be applied to the proceedings.
What is Section 5?
Your Lordships, the council would like to answer that question at the end. Basically, the case of Babulal essentially held that the Limitation Act is applicable to the insolvency proceedings, which was also held in the which was also recognized under Section 238A of the IBC 2016, Your Lordships.
So even in this case, it was held that date of default can be the date in which of declaration as NPA as well. It was held in this case.
Indeed, Your Lordships.
Yes.
So this is the submissions with respect to issue 3, wherein the date of default indicates as to when the first default had occurred. The subsequent acknowledgement only extends the limitation period, and thus the facts and circumstances should also be considered in determining the application. But the date of default serves as an objective indicator as to when the first date of default had occurred. So this is to prevent the frequent litigations as to, because when the creditor cannot initiate insolvency proceedings based on any acknowledgement of debt that has been served years after when the default had occurred. So thus this is with respect to the submissions of issue 3. If the councils are satisfied with the submission of issue 3, the council would like to proceed with issue 4.
Yes.
No, but there the other side's argument is that it's a continuing cause of action. So if it's a continuing cause of action, then even if the first date of default can be, say, 7 years back, that can be the first point at which the limitation started. But if it's a continuing cause of action, then if in reality it is a continuing cause of action, then even after 7 years from the date of first default, an application can still be filed. So as a proposition of law, if they're arguing that it's a continuing cause of action or a continuing case of default, they are not wrong. But you have to convince us that how is not a continuing cause of action, because their case is that it's a continuing cause of action, and therefore the limitation will keep on getting extended as and when a new fresh cause of action triggers. What is your argument to counter that argument of the other side?
Indeed, Your Lordships. So, had the acknowledgement of debt in the instant case, you have provided the example that if the NPA was classified 7 years and had they provided acknowledgement of 7 years later, Your Lordships, had the acknowledgement of debt had been accepted by the financial creditor, for instance, if they had the OTS letter which was issued by the corporate debtor, and that it was accepted, and then the corporate debtor defaulted upon that payment, can the proceedings be initiated under section 7. However, in the present case, the OTS was not accepted. It was accepted during the COVID period, which was again bared under the section 10A of the IBC, Your Lordship. So that is our submission. So thus acknowledgement of debt has to be accepted by the financial creditor.
Yes.
If the councils are satisfied with the submissions of issue 3, the council will like to proceed with issue 4.
Yes, first.
Your Lordships, the issue 4 deals with whether the second application can be filed under section 7 despite an error in the former application. Your Lordships, the council has two broad submissions to make with this respect. That number one, the second application is not only bared under the principles of res judicata as has been deliberated by my co-counsel, but also under the order but also under the CPC order 23 of the CPC rules, which CPC rules. Our second broad submission is that the
No, what rule of CPC? Order 23, which rule? Rule 1, Rule 2, Rule 3.
Your lordship, rule 1 subclause 3 of order 23. So
Can you please read
rule 1
that?
subclause
Can you
3.
please read that? Can you please read that?
Indeed, your lordship. So uh, basically uh, CPC, it provides that if the court had there been any kind of technical mistakes or any formal defects in the application, and the court then the court allows that fresh application may be filed in case if there was a formal defect. But when the applicant had filed the section first application under section 7, the date of default was mentioned as the year 2020. This mentioning of the year as 2020 was intentional and not a clerical or a technical error. Had there been a technical or a clerical mistake, the appellants had the opportunity to withdraw their initial application and had requested the court that there was a technical error. But indeed, they chose to file an appeal before the NCLAT, contending the grounds on which the NCLT had rejected their application. This clearly indicates that there was indicates that there was that this was not a procedural mistake,
Intentional.
but
That
rather
this
an
was
intentional.
intentional. Right.
Indeed, your lordships.
Right.
So, to deliberate upon the first submission, yeah, indeed, your lordship. So, this was with respect to with our submission 1. So, our second submission is that if the present application filed by the appellants is admitted, it defects the very it goes against the very purpose of the IBC, which is to provide for a quick and efficient method for resolving debts, but also uh, and thus it also provides for continuous litigation. Your lordships, the council would like to deliberate upon the case of Mobilox Innovation Private Limited versus Kirusa Software Private. Your lordships, this was a judgment delivered by the Supreme Court of India in the year 2017, wherein it was recognized by the Supreme Court that the IBC is not a debt recovering mechanism, but rather a tool to for the resolution purpose, to bring a company which is in financial distress into a normal position. So here the first application filed by the appellants clearly indicates that it was an intentional that it was an intentional it had mentioned the date of default intentionally, and that if had there been and that no opportunity um, uh, and that and that the second application filed under section 7 should not be entertained, your lordships. So that is the council submission with respect to issue 3 and issue 4.
Yes.
If the councils request the court's permission to proceed with the prior, your lordships.
Yes, proceed.
Wherefore, in the light of contentions presented, arguments advanced, and authorities cited, the counsel for the respondent most humbly and respectfully submits before this Honorable Supreme Court of Indigo that it may be pleased to adjudge and declare that the second application filed under Section 7 is not maintainable, and that it is barred by the principles of res judicata. Secondly, that the mentioning of exact date of default is not merely a procedural nature, but rather mandatory. Thirdly, the date of default may vary. That the date of default does not vary on facts and circumstances. Rather, the acknowledgement of debt serves as only extends the limitation period, and that the date of NPA should be considered. Fourthly, an application under Section 7 must not be admitted where default has occurred and the petition is despite the debt and default being occurred, unless it was only a procedural misdescription, but when there is a genuine clerical mistake, your lordships, and or pass any other order that it may deem fit in the favor of the respondent to meet the ends of equity, justice, and good conscience. For this act of kindness, the respondent shall duty bound forever pray.
The council seeks permission to approach the dais for making the rebuttals.
2 minutes. Yes.
Yes, yes, Lordship. Firstly, my learned friend stated that the second application goes against the legislative intent of the Section 10A of the Insolvency and Bankruptcy Code. Your Lordships, I would like to point out that the Section 10A was enacted through an ordinance which provided relief to the companies who had genuinely suffered from losses due to the COVID-19 pandemic. Whereas in our case, uh, the corporate debtor was classified as an NPA and started making defaults in 2014, which is nowhere near the COVID-19 pandemic period. Secondly, as my learned friend pointed out that the date of NPA shall be taken as the date of default. Uh, my lordship, I would like to say that who is to determine this date of default? Is it a bank who classifies a debt as an NPA, or corporate debtor who commits the default and thereby pertaining to the facts? The default has been the date has been classified. Uh, uh, Thirdly, your lordships, learned that application is untenable. I would like to humbly submit that an incomplete application may not be admitted by a adjudicating authority, but it can be rectified uh, by giving an opportunity to the financial creditor to rectify and amend the application.
But you tell me one thing.
Lastly,
Just a minute. Just a minute. But you tell me one thing. You filed an appeal on merits before the NCLAT. So they are right in saying that had it been an error on your part, or had it been the fact that you discovered that error, or you discovered that loophole in your application, then the correct course of action should have been to seek the leave of that court itself or NCLT itself, and you should have sought the leave of NCLT to amend your application. So when they say that this all was intentional on your part to delay the whole proceedings, that first will go to NCLT
indeed,
with
your
a
lordship.
defective application, then you will go to NCLAT before appeal, in appeal, and with the same application, and challenge that NCLT's order on merits, then in that case it's
They,
not something unintentional. So they are not completely wrong when they say that that was intentional on your part. That's number one. Number two, they have cited the judgment with this on this proposition that the date of default would be the date on which the bank declares the account of the corporate debtor as NPA. They have cited a judgment. So, do you have any judgment which says otherwise? Because that would end the matter. So, if you have a judgment, this is the right time to bring forward that judgment.
Your lordships, in the case of Dena Bank versus Shiva Kumar Reddy, in the case it was held that uh, default date of default is not frozen when the debt has been classified as an NPA.
Can you share the screen? Can you share the screen?
Just a minute, your lordship.
Or can you read that relevant para for us? Can you read that para? You have the copy of that judgment with you.
Your lordships, it is given in my memo, the memo reel.
Can you read?
Just
Can
a
you
minute.
read the relevant part? Yes. Yeah. Take your
Uh,
time. Take your time.
in this case, this court has held that subsequent acknowledgement or part payment may furnish a fresh date of default, your lordship. And a creditor may initiate CRP based on the last acknowledgement of default, not just the NPA. That
All right.
is
All right.
what
So
happened in
basically,
this case.
you are not disputing the fact. Basically,
The
what
N
you are suggesting is you are not disputing their fact, but you are saying there is a fresh
Yes, your
acknowledgement. So
lordships.
there is the limitation extends. You are
Yes, your
saying
lordship.
that. You are saying completely different. Yes. So that's also not
Yes.
wrong. What you are saying.
I would like to complete my last point, your lordship. My learned friends also referred to the CPC, in which they stated that in case there is a formal defect, the application can be allowed, which is very much understood, your lordship. But I would like to point out the object of the IBC. It is to empower the financial creditor. So as it changes the mechanisms of the corporate debtor, so it can be is a very situation for both, not just the financial creditor. It is also beneficial for the corporate debtor as well. So if such a minor defect is not looked at in the application, your lordship, it could also be beneficial for the corporate debtor as well, and uh, it could be revived and the debt could be recovered, your lordship. I would like to complete my submissions. Thank you.
Your, the co-counsels request the bench to proceed with rebuttals.
Just 2 minutes.
Indeed, your lordships. The first contention that was raised by the appellants is that the date of that there is a genuine date of that there is a genuine default and debt. However, in the instantaneous case, we as respondents neither are we contesting that there is no default or debt, or that have extinguish the limitation period. However, we are contesting that the procedure that has been adopted by the appellants in filing an application under section 7. Furthermore, the appellants also stated that the very objective of IBC is to empower financial creditors and to initiate an insolvency proceedings. However, your lordships, such a mechanism cannot be provided at the cost of intentional misrepresentation. They have repeatedly contended that it was merely a minor defect, which the respondents have addressed during their submissions, that it was not a minor defect, rather it was an intentional misrepresentation. Such an intentional misrepresentation cannot come at the cost of substantive justice, your lordships. Furthermore, reference was also made to Dena Bank. Here, the legislative intent here is referred only to highlight the highlight that no that the Dana Bank does not cover that aspect, your lordships, of determining the date of default. Secondly, the honorable lordships had also posed the question with respect to what Section 5 of Limitation Act is. The council would like to answer that question. The Section 5 of Limitation Act basically states that provides excuse in delays in filing appeals or applications if party shows sufficient cause. However, in the present case, there is no sufficient cause for the sufficient cause which has been and that there was a genuine
Yes.
misrepresentation by the respondents.
Yes. We'll just discuss. Mr. Sagar?
I'll request the